are Mark Lennon, Secretary of Unions New South Wales, and Ken Phillips, Executive Director of the Independent Contractors Association. Gentlemen, welcome. Ken Phillips, let's start the debate. What did you learn from the Graham Kirk case?
What we have to understand with work safety laws is that when there's a prosecution, this is a criminal matter. And people need to realise the seriousness of that. All of us, when we are confronted by criminal law, realise that there are certain protections and principles in place that protect all of us and our safety and the notion of criminal justice. And it's very simply that we are presumed to be innocent. And the prosecutor must mount a case and prove that we are guilty. Now, the laws in New South Wales take all of that and dump them in the bin. The work safety laws in New South Wales say that simply because an incident has occurred, you are guilty, that you must prove your innocence. And when the Kirk case came out and we saw the comments by the High Court has said that the prosecutor not only failed to comply with the Evidence Act in one instance, but failed to produce evidence of what was happening and that there was any guilt.
Mark Lennon, the Kirk case does tend to discredit, given the nature of the persecution, not the prosecution of this individual, discredit the New South Wales regime, does it not?
Let's just get the law in New South Wales very clear. In the first instance, when there's been a breach of our laws here, it's incumbent on the prosecutor to prove that there has been a breach beyond reasonable doubt. Following that, they have to prove that there was an employee who was impacted by the breach, and if there's been an injury or risk, there's been a risk to the employer that has in fact occurred. So all that onus rests with the prosecutor, and the onus there is, of course, beyond reasonable doubt. It's only then that when a defendant wants to raise its defence that it has to show that it did everything reasonably practicable on the balance of probabilities, the civil level of proof to try and prove that it did everything it needed to do to ensure that it did everything reasonably practicable.
Do you agree with that?
Mark, in my view, you're spinning it. The High Court was very, very specific here. It, in layperson's language, called the laws in New South Wales unconstitutional on the basis that the laws do not guarantee an individual's right to normal criminal justice. And that's really the end of the debate from the aspect of the law and the structure of the law in New South Wales.
I don't want to get into a lawyer's debate here, Quentin, but very clearly, and I've read two lawyers' advices on this in the last 2 days, that in the end result of the Kirk case was simply this, that where a prosecutor is where a prosecutor is running a case, they have to lay it out very clearly to the defendant what steps they should have taken to try and prevent the breach.
Ken Phillips, do you acknowledge that unscrupulous people, negligent people, should not be given any tolerance whatsoever when it comes to workplace safety?
No question of that at all. And,
in which case the enforcement regime is important.
That is the design model of the harmonisation laws. That is the design model of the Victorian laws, which have been in place now nearly a decade. The design of the New South Wales laws is that it does not hold everyone responsible. That's its basic flaw.
We're not protecting or arguing for the retention of all the New South Wales laws. We accept there are changes that are going to occur as a consequence of the harmonisation.
What's the deal breaker for you that Christina Keneally is seeking this exemption apparently on your behalf?
We have said that the most effective provisions, and the New South Wales government agrees, the key provisions of their legislation, are the reverse onus of proof and the right of unions to launch prosecutions. We believe those two aspects should be retained. We accept there has to be changes to the law. We note there are key changes under the harmonisation law, qualification of the duty of care, for instance, a limitation on who's an officer who can be prosecuted. They're changes. We accept rights of appeal. We accept all of those. Just these two key provisions should remain.
If you have in these laws automatic assumption of guilt, you trash the basic principles of criminal justice and you create an environment, which is the environment in New South Wales where you cannot trust the prosecution process. The scathing comments of the High Court towards the behaviour of the prosecutor in New South Wales brings all of the faith of people in the independence and proper application of laws by the prosecution authorities of New South Wales into question.
Mark Lennon, you're still going for the reverse onus of proof. Prove to us that such a regime reduces workplace accidents.
Well, first of all, let's go back to Ken's point that he keeps saying about this presumption of guilt. That is not the case under legislation as it presently stands in New South Wales. It is incumbent on the prosecutor to prove that there has been a breach of the legislation. Secondly, Ken's made an interesting point there about the High Court. The emphasis was, in the High Court case, about the actions of the prosecutor in that case in New South Wales, the WorkCover Authority. Now, I'm sure they have taken lessons from that decision of the High Court.
They won't run any case like that again, eh?
Well, it's understand that, for instance, WorkCover in the last 3 or 4 years has run less prosecutions. They've changed the way they operate in this state. Part of the problem has been not about the laws themselves, but the way they've been enforced.
No, Mark's wrong. The High Court was quite clear. It said the state of the Parliament of New South Wales did not have the constitutional authority to create the laws that it created.
Okay, they're unconstitutional.
They are unconstitutional.
Okay, let's just talk about keeping people safe at work. Ken Phillips, would not a New South Wales regime be more effective in keeping people safe at work?
Quite the reverse. It sets up an environment in which people feel that they don't have to be responsible for safety. Victoria had this debate back over 10 years ago. They were looking at putting in a New South Wales type model. They rejected it. They put in a regime of work safety laws which says that everyone is equally responsible for safety, and Victoria and the other states are doing substantially better on the work safety front than New South Wales.
Mark Lennon?
Well, again, I contend that's a contentious issue about who's
doing better. This is your chance. Where's the figures?
Well, the figures that came out last week, as a matter of fact, the Workplace Relations Ministerial Council's comparisons of all the jurisdictions when it comes to occupational health and safety showed in the 12 months to the end of June last year that the lowest number of fatalities in any state were in fact in New South Wales. You can have a very long argument. We'd be here all night arguing, comparing figures from state to state. We accept certain aspects of the Victorian legislation.
New South Wales better safety record, you say?
I say that yes, in recent times.
I say it's worse.
It's worse?
Yes.
Surely there could be some factual agreement between us.
But let's take the point here, Quentin, that I'm accepting that there are changes to the New South Wales legislation, and we are picking up aspects of the Victorian legislation, as Ken alluded to, and we're picking up aspects of other states. All we're saying, there are two provisions that we think have been very effective in New South Wales that should remain. So we accept change and we accept allegedly better provisions from elsewhere.
The head issue with work safety laws is, do you apply presumption of innocence or presumption of guilt? It's the key issue. New South Wales wants to go in one direction, the rest of the states are going in the other direction. And I've got to tell you also, New South Wales is in breach of the international obligations under the ILO conventions on this.
Can I just go to, first of all...
Presumption of innocence.
Sure, and my point is there is a presumption of innocence. The onus...
Not with the reverse onus of proof. If somebody gets killed on your property for reasons that you aren't responsible for, you're held responsible. You are criminalised.
Well, let's just go through it. First of all, you have to make sure that someone's killed on your property, you owe them the duty of care. Secondly, that there's been a breach of that duty of care, that you had a relationship with that person as a consequence of the breach, that's what they were killed. That all has to be proven by the prosecutor. You agree, Ken?
All the other states do that. The only difference is...
Okay. No, but
in New South Wales they say you're already guilty, and the other states say, we'll presume you're innocent.
No, they didn't. They said you have to prove all that in the first instance, so they haven't said you're guilty.
No, that's not what the High Court has said.
Gentlemen, we're going to have to get more legal advice. Ken Phillips, Mark Lennon, thanks very much.
Thank you very much.